Good afternoon, everyone. Apologies for being very slightly late in terms of getting this started, but it's 2:05 p.m. Thursday, August 12th, 2021, and you're watching episode 4 of the Will Chamberlain Show here live on Twitter, live, YouTube, and Facebook at the moment. Before we get going, you're watching this on any of those platforms. We do very much benefit from the fact of you liking and subscribing to these things. So if you haven't, go to youtube.com/human events and hit that subscribe button and that bell that gets you notifications of when I go live, which should consistently be around 2 p.m. Eastern, but you never know, maybe I'll have a, impromptu live stream after some important event. If you're on Facebook, hit that like button, facebook.com/human events media. And if you're on Twitter, go and get notifications and hit the bell for when I go live. You'll be able to get access to my live streams when they happen. But today, over the past few days, I've been kind of doing a broad-based analysis of a lot of the news of the day. Today, I'm doing kind of more of a classic deep dive. And the deep dive is going to be into a piece of news that came out last night that I actually talked about with Tim Pool on his show, but only in kind of a cursory matter. This morning, I've spent kind of more time analyzing the pleadings, analyzing in detail what happened. And what happened is that we had kind of one of the first major developments in some of the lawsuits that Dominion has filed against various figures on our side. And that is that a federal judge has rejected Powell's argument that no reasonable person would believe her election fraud claims were statements of fact, and that Dominion suits against her, Giuliani, and MyPillow will go forward. Now, I first got this. I saw the news of this motion to dismiss being lost. I saw it last night when I was at Tim's, and I kind of quickly tried to read the complaint and read the ruling rather, and get a handle on what was going on. I did find a couple of things that, immediately that jumped out at me as things you never want to see a federal judge saying about you. I think in particular, this is where essentially the judge is talking about one of Powell relying on an expert who had, quote, publicly claimed that George Soros, President George H.W. Bush's father, the Muslim Brotherhood, and leftists helped form the deep state in Nazi Germany in the 1930s, which would have been a, quote, remarkable feat for Soros, who was born in 1930. That's something you don't ever want to see a federal judge do to you. If you're in front of them and they're clowning on your arguments or they're making fun of the things you said in the past, that's a bad indicator for how future rulings are going to go against you. Similarly, there was a problem here about something Mike Lindell, basically characterizing Lindell's view. And this is something the judge wrote, quote, as a preliminary matter, a reasonable juror could conclude that the existence of a vast international conspiracy that is ignored by the government but proven by a spreadsheet on an internet blog is so inherently improbable that only a reckless man would believe it. And this is relevant because recklessness it goes to the heart of the actual intent standard that would be used to determine whether Lindell wins or loses this case. So I feel like it's important to talk about this. Mike Lindell's obviously got his cybersecurity summit going on right now. And this opinion just dropped right in the middle of that. And while this opinion doesn't resolve these debates, obviously Lindell will still have a chance to present his case, present his evidence. It does not bode well. And so I want to go in, so having seen this ruling, I kind of want to go into detail about what it's saying and why it bodes so poorly for the defendants in this case, and also why it's going to create a problem, I think, for almost everybody else who's being sued. Because remember, Dominion's not just suing. Dominion is not just suing Sidney Powell, Mike Lindell, Rudy Giuliani. They're suing Fox. They're suing OAN. They're suing Newsmax. They're suing multiple employees of OAN, Chanel Ryan and Christina Bobb. And, all these cases are in the District of Columbia. And so I want to talk about some of the things that happened. So without further ado, here's the opinion. Let's go ahead and kind of make this a little larger so people can kind of see what's going on and get a chance to read it more effectively if you're at your desktop. I know it's going to be tricky to read no matter what if you're watching this on a phone, but I'll make sure to try and quote it for you. So this is an opinion that essentially consolidated everything that all Sidney Powell, Rudy Giuliani, and MyPillow and Mike Lindell all filed independent motions to dismiss. And basically the court, hearing this, consolidate all their motions and dismiss them all in their totality, right? It says right here, for the following reasons, the court denies their motions in full. And there's a variety of arguments that were proffered by Giuliani, by everybody else. And one of I think the big thing, hold on, let me make sure I pin this here. A big thing to keep in mind is like what exactly was essentially the big arguments here. And to understand that, you kind of need to understand, like, let's talk about kind of the phases of civil litigation. That's a very important thing to start out with. Okay. So civil litigation starts out, you as the plaintiff get up and you file a complaint. You basically allege everything that the other side is doing wrong, that basically, and your allegations at that point don't have to be proven by evidence. So you're just alleging the things that you hope to prove through discovery, through documentary evidence, through testimony, etc. And at that point, you can be kind of liberal, especially if you're actually filing a complaint. So phase one is you file the complaint, and then the first thing that a defendant can do is they can file what's called a motion to dismiss. And a motion to dismiss, that's a way to hopefully, from the defendant's perspective, end the litigation ASAP, right? Get it over with. No discovery, no massive amount of money spent on lawyers, no depositions. You have to sit for 8 hours and get interrogated by another lawyer. None of that. And that's what you're trying to accomplish. It's hard to prevail on a motion to dismiss because courts generally want to make themselves available to people who file complaints, because that's how justice is done. People want access to the legal system. So you can only win a motion to dismiss if you demonstrate you can demonstrate a few things: that the court does not have jurisdiction over you, like the power to adjudicate a dispute involving you. That's something you can do, and it actually was tried here. Or you can win on what's called the most classic motion to dismiss, the most often resorted to, is what's called the failure to state a claim. That's Rule 12b-6. So I'll kind of pull that out. And this is the Legal Information Institute at Cornell, and it's very, very useful. This is Rule 12 of the Federal Rules of Civil Procedure. I actually got to make sure I put that up. Rule 12 of the Rules of Federal Civil Procedure: defenses and objections, how they're presented. And then here it is, 12b, how to present defenses. You can assert this claim in a responsive pleading, which is something you would respond with in the first 3 weeks. And a 12b-6 is failure to state a claim upon which relief can be granted. What does that mean? Well, it means that even if everything the plaintiffs are saying in their complaint is true, the judge would not be in a position to grant relief. You have not stated a claim. You have not said anything that amounts to anything that a judge could do work with. In the context of defamation law, that has to do. The basic idea there is, the most obvious place that you can, win on a failure to state a claim is if the complaint fails to allege, for example, actual malice, and you're a public figure. And actual malice is knowing, lying, or reckless disregard of the truth. Another thing you could allege is, you could say in a motion to dismiss to try and get the litigation thrown out right away, is I didn't even make a statement of fact, right? Like, they're just talking about things I said. Those things are opinion, not fact. As a legal matter, this could not possibly be defamation. So this case should get thrown out right away. Another example would be they never pled damages. You could say, as a defendant trying to get a defamation case thrown out, you could say, look, the plaintiffs get up there and say I lied about them, but they never explained at all how they were hurt by that. And so you, as a court, there has to be damages for there to be a lawsuit. If they didn't even explain that, you could toss it out that way. So that's the kind of arguments you'll see. What you generally don't see is like very specific evidence-based debates about whether or not the allegations are true, right? Whether or not, if Mike Lindell made claims about Dominion, like the question is, are those true? Are those not true? You won't generally see a lot of debate about that, because that's an evidence-based debate, and we're not at the point of a litigation where there's evidence. So again, file a complaint. First option to try and get the case thrown out is a motion to dismiss. Next, then is discovery, right? If you get past the motion to dismiss, you get discovery. That's when you have depositions, which are sort of, everybody sits down. This handled. Depositions are outside of court. The lawyers handle it themselves, and essentially, if you are deposing, you have the right to depose each other and other related parties that have evidence that they would theoretically testify about at court. The deposition is also under oath. It's sort of like you're getting a preview and sort of figuring out what this person would say in court. You're getting a sense of what evidence they would provide in testimony. Then that's also where you get document production. You have the right to request like relevant documents from the other side, and they have the right to request it from you. And that's where you basically, the discovery phase is like the assembling and putting together of all the evidence, right? Like getting a handle on everything that would be testified to, getting a handle on all the documents. And then finally, then there's a motion for what's called summary judgment. And the summary judgment motion is a question about, the standard there is whether there's a genuine dispute as to any material fact, meaning it's like, now that we have all the evidence, is there any way a reasonable jury could find that some relevant, important fact was true or not true? And sometimes, like the idea of there being, sometimes you've just so dramatically demonstrated that you are correct on the evidence that the judge says there doesn't even need to be a trial. That would be something. Or there's not a relevant dispute as to anything that's important. Maybe the part, one side is arguing about things that actually don't matter to the questions the judge has to decide. So that's that's where, no genuine dispute, a material fact. So that's another place the defense can get things thrown out. If they don't prevail there, then the place they finally can go to is that's trial, right? If you lose your motion on summary judgment, then you go to trial. And so right now we're early on, right? That's the key thing to understand with, and we're very early on in a lot of other cases too, right? We're not even at the motion to dismiss stage with Fox News, OAN, Newsmax, right? Those cases were filed very recently, but we're still early on with Powell, Giuliani, and Lindell and MyPillow. We're now at the motion to dismiss phase. And so you might think, okay, well, they lost a motion to dismiss. How bad can that be, Will? Here's the thing. It's not necessarily just that they lost the motion to dismiss. It's the way they lost it. It's the way this opinion is written. Because in an opinion, you get a sense as to the judge's thinking, which would forecast how they are going to resolve future cases. And here's, I think, the problem that you're going to see. The way that essentially they lost these cases is not good. And I highlighted some of the reasons before. So basically, the way the court looked at this is, we're getting through kind of I'm going to skip through a lot of the kind of introductory material to get to the substance of the dispute. One of the things as a lawyer you get to understand is how to kind of scan through legal documents and get to the parts that really matter, just so you know. So this is all like background, legal standard, all very standard. Now here, analysis. This is where we actually get to the heart of what the judge is saying and why. Okay. So first argument that the judge just tries to dispose of. Sidney Powell, in her motion to dismiss, tried to argue that what she said were not statements of fact. As I talked about, if you can establish that all you said was opinion, then you couldn't possibly have committed defamation. For something to be defamatory, it has to be capable of being proven true or false. But that said, as the judge says here, for a statement to be actionable as defamatory, it must at least express or imply a verifiably false fact about the plaintiff. But ultimately, the judge pretty clearly concludes that many of the things Powell was saying about Dominion, Venezuela, how the election was rigged, are factual, or at least capable of being proven true or false, and thus basically just kind of dismisses this objection very quickly. For example, just to take, I'll use a very quick example that the judge points to. Powell stated that she could hardly wait to put forth all the evidence on Dominion, starting with the fact that it was created to produce altered voting results in Venezuela for Hugo Chavez. And the judge says, again, this statement is either true or it is not. Either Dominion was created to produce altered voting results in Venezuela, or it was not, right? Like exactly the kind of core thing that you would be, is that, again, that's a factual statement. And so Powell did not prevail on this. There's a lot of work that the judge does to explain how her statements are factual. They're not pure opinion. And so that she's going to lose on this. The next one is the really big one. This is the one where I thought I was actually kind of surprised at how badly Powell and Giuliani and Lindell ultimately did. Basically, like everybody thought they were going to get this case tossed on actual malice, and the reason being, kind of to just like get to a high level, actual malice. It doesn't just mean like you were negligent. It means that you either knew that your statements were false, or that you kind of disregarded a risk that their statements were false. And there has to be some element of intention, right? Some element proved ultimately that you knew what you were doing was wrong, right? It's not merely that you were negligent. If you honestly believed you were telling the truth, then that's a defense to defamation under an actual malice standard, right? Okay. So you think, well, clearly, I mean, if I personally think that both Sidney Powell and Mike Lindell think they're telling the truth. I don't think they're knowingly lying, right? Let's just get that out of the way. I don't think they're correct, but I don't think they're knowingly lying. But the question is, at the motion to dismiss stage, has Dominion alleged sufficient facts for a reasonable jury to find that they were knowingly lying? That's a lower standard. Like, were they in fact knowingly lying, or has Dominion said enough to make it possible for a reasonable jury to think and to decide that they were lying. Okay, that's all they have to do. And this actually a low enough standard that basically Dominion was able to get over it with all three defendants. And I think basically you can see the type of arguments that were made and basically that how Dominion cleared the bar. So this is for Sidney Powell, but this is actually how it was framed in the context of also for MyPillow and Lindell. Quote, as to Powell, Dominion contends that it is alleged, not like a few things. One, quote, Powell's claims are so inherently improbable that only a reckless person could have believed him. So that's one way to allege actual malice. Two, that she deliberately ignored the truth in favor of relying on facially unreliable sources. Three, intentionally lied about and fabricated evidence to support a preconceived narrative about election fraud. And four, did so to raise her own public profile and make profits. So those are the allegations, right? It's not that those things are necessarily true, but those are the allegations. And basically what the judge does in each of these cases and says, like all of these, basically that's enough, right? If indeed Dominion has alleged these things and it is legitimate, they have a basis for alleging them. It's not necessarily that I'm like fully evaluating, the judge isn't saying it's true, it's false. He's just saying they have a basis for alleging these things. And therefore, that basically the lawsuit can go forward. And that works, and that's where they kind of go, the judge goes into some of the detail about the very specific claims that Powell made and Lindell had been making, and does a little bit of the dancing around like that I talked about at the very beginning of the show. Things like, right here, quote, the expert is publicly claims Soros, if H.W. Bush's father, the Muslim Brotherhood, and leftists formed the deep state in the 1930s. Like, that's where it's going. So basically, like on the two big issues, they got past the motion to dismiss on substance, right? The judge basically rules, look, the Dominion has adequately alleged all the elements of a defamation claim. They have a basis for doing so. And also just given the sort of like jokes that the judge is telling at the expense of the defendants, like it's pretty clear the judge thinks this is all right. Like it's pretty clear at this point, the judge thinks that there was defamation here. Now, that's not the end of the story, right? The judge is not the ultimate arbiter of the case. There's going to be a jury trial and the jury will ultimately have to do it. But that's where we get to the second problem, and the second big bad thing that happened for the defendants here, and that's they lost their jurisdictional challenges. And I'll explain that. So, jurisdiction and venue; these are sort of two different but related concepts, and they have to do with where someone can be sued and where the trial is taking place. Right. So so federal court, right? Like there's two different types of jurisdiction. There's what's called personal jurisdiction, which is whether they have the right to sue you at all in that location. And then subject matter jurisdiction, which is whether a federal court has the right to hear it. Here, the only focus is on, I think for the most part, actually, I'm not the only focus, but the most part is personal jurisdiction. And quickly to answer a question, not a lot of civil litigation gets dismissed. A decent chunk of it actually does. That's because a lot of people are actually fairly incompetent in terms of filing their lawsuits. So a decent chunk actually does get dismissed. And basically, here's the problem, right? Right now, this case is on track to be tried in the District of Columbia, right? And so that's the ultimate arbiter, right? Is a jury in the District of Columbia. Okay, that's going to be 12 Democrats deciding a defamation case from like this Dominion election machine company against Trump figures. That's a nightmare. Like I guarantee you that the lawyers for Powell, and MyPillow and Lindell and Giuliani and everybody else are saying, we can't have this case in the District of Columbia. This is a disaster waiting to happen to us. And so they tried really hard to explain why this case shouldn't be moved. And they said, one, they try to make the argument, well, Sidney Powell's from Texas and Mike Lindell is from Minnesota, and they don't really do business in DC. And so it's not fair to hold them to, have a trial of them in DC. And basically what the judge said is, well, and to my knowledge, this is a basically accurate way of understanding jurisdiction. It's like, well, the problem is you had things to do with DC. You had contacts. That's sort of the basis for saying you have jurisdiction. It's the minimum contacts test. And Powell and Lindell would routinely come to DC for their dealings with the government. Powell was actually on the stage for that press conference. And it really doesn't take much. That's the thing to understand. It might seem like, oh, these are trivial, whatever. But for the purposes of this test, just like minimum contacts with the area is enough for jurisdictions, enough for a court to say, we feel we have the right to hold you, to bring you to court here and for you to be on trial here. Like, it'd be one thing if like Lindell had never stepped foot in DC, or Powell for that matter. Then they might have a real claim here. But in general, personal jurisdiction is not, it's hard to dismiss a case on that basis if you have reasonable contacts with the state. And then the second thing they try to do is say, okay, well, maybe you have the power to hear the case, but you shouldn't hear it here. You should hear it in Minnesota, where Lindell is, or in the Northern District of Texas, where Powell is. That's what's called a venue challenge. And that's say, okay, well, you can hear the case here, but you shouldn't. And they also lost those challenges too, on the basis that enough of the activity that's at the root of the complaint, like enough of the supposed defamatory statements and was made, those statements were made in, a lot of those statements were made in DC. So the court dismissed those challenges too. And that's even worse, I think, ultimately. What you have is a situation where now the court, they've tried to get the substantive claims dismissed, that failed. And they've tried to get the case moved out of DC, that failed too. So what are we aiming towards here? Well, maybe they could try and hopefully win on summary judgment, which we talked about before, proving that there's no genuine dispute of material fact and that the Powell and Giuliani are entitled to judgment as a matter of law. But they're just not likely to win those claims. And so what we're looking at here, and what Powell and Giuliani and Lindell and MyPillow are all looking at, is a trial in the District of Columbia in federal court, in front of a DC jury of liberals, about whether or not they defamed these companies. And, ultimately, if they can, basically they will have to persuade a DC jury that they really honestly believe these things and that they did not engage, that they did not have actual malice. That's really their only hope. And if they had a more favorable jury, maybe they'd be able to do that. Maybe that would be likely. But I suspect that I don't think a jury trial will go well in the District of Columbia. Like, think about all those criminal trials that went horribly for Trump defendants, right? Like, it's just a really, really bad situation. And so I'm sitting here being like, if I'm their lawyers, I am saying we need to settle this case, guys. Like, we are going to be in huge trouble. Now, there's some talk about, Lindell talked originally, I think, about how he was, we talked about this on Timcast yesterday. Lindell talked about how he was, very enthusiastic, to get to the bottom and to get discovery and to get evidence. And maybe he still is, but I don't think that's not enough. That's not really that wise to think that that's going to solve all these problems. And that's part of the reason I think he ultimately, I'm sure his lawyers told him, like, no, you need to file a motion to dismiss here. It's not a good thing that you're being sued for this. And part of the problem is, this is something that is in the filings, and Dominion did a very good job of, sort of explaining, is they were basically like, we had a $500 million business, and that business has been irreparably damaged by the conduct of the defendants. And they're asking for $600 million in damages. You don't want to, like, just gamble and, go ahead and roll with $600 million in damages. You don't want to do that. And so I'm sure that's the reason they're fighting this tooth and nail. And so and it's just a very, very bad situation. I'm putting my marker down now, right? Like, it's going to be very bad financially for all the defendants here. I think it's going to, the ultimate consequence of these cases is going to be rough for conservative media broadly. I think OAN and Newsmax have their own serious problems, that it's going to be very hard to dismiss these cases, that if there's held in front of a jury trial here in the District of Columbia, it's going to be real bad. And yeah, I think things are not going, this is not going to be good. Somebody asked a question. What about the fact that many states, Texas included, turned down Dominion for handling elections because they could not prove they were inviolable? That's going to go to damages questions. And ultimately, damages are something that'll have to be proved to a jury in the same way that, the defamation or actual malice would have to be proved to a jury. I think, there will be some good arguments that Powell and all these defendants have about whether or not their particular statements caused the damages to Dominion. but it's not a good situation for them. And I think we haven't really gotten to the heart. Like, everybody is so focused on the symposium that's happening in South Dakota that Mike Lindell is doing. But you have to realize that whatever happens in that symposium, it's looking more and more like their businesses are on the, their livelihoods and businesses are on the line and potentially at fatal risk in DC. Like, what My Pillow company could be bankrupted by this. I don't think My Pillow is a $600 million company. I certainly don't think they have $600 million in cash laying around. Maybe they do. I hope they do. But it's one of these things where I'm sad to see it, because I like Mike Lindell. I think he's a nice guy. I think he's good-hearted. I think that My Pillow is a good company. I like that they support friends of mine very much. And I'm very, very worried and concerned about what's happening here. And I hope that we can see a settlement and get this litigation undone for these people, or not undone, but rather resolved. And that's something I think is, and we need to talk about more than, people need to realize, and it sort of connects to a broader theme, which is that I think our side has not really strongly considered the downsides of the path of going hard on fighting on election fraud. And not talking about like future, fighting to vote for future election integrity. That's a different thing. But like trying, being very, very reckless about the statements that we've made currently, is that like I think there's real damage, financial damage that was done to Dominion, which is not, I don't care. Like, I don't have like some more, I don't really care morally about like what an election company. And I think it's like, oh God, we must protect Dominion's reputation. No. But rather, as a pragmatic matter, it's very reckless. And it's a thing that I think people are just really, really underestimating the potential damage that this can do. And so that's something I'm kind of disappointed by. And, I encourage you to read this material for yourself. One of the things you can understand, you can do really, this is to understand like what's happening in these lawsuits. It's a little hard to read if you're not like super familiar with how to read a court docket. These are all available. All this stuff is publicly available. Like the site that you need to look at is called Court Listener, because they are basically the repository for publicly available court documents. And so you can read things like, this is the entire lawsuit against Powell in the District of Columbia that you can read for free. The complaint, and then, motions to dismiss. And ultimately here's where, just yesterday, August 11th, that you have this memorandum and opinion, and you can just click and read all this stuff. So, check my work if you want to, but this is what I'm seeing. And yeah, I'm sad, I'm disappointed, but I think we aren't doing a good job on the right of kind of like reporting on the stuff that's happening. I mean, this is an important event for all the parties involved, and it's very relevant to all the discussions of election fraud. And so I think that we needed to talk about it. With that, we're going to switch phases, right? I don't know if you guys are super familiar. You are, we're in this, I always try and do this podcast in a way that makes it listenable as a podcast for the first 30, 40 minutes, and then switch phases into a discussion of the comments. So this is now the time where if you want to like ask me a question in the comments, no matter what format where you're watching this right now, if you're watching it on Twitter, you're watching it on Facebook, you're watching it on YouTube, if you make comments, I see them and I get them all aggregated in my StreamYard feed. So I'm going to kind of go through those now, put them on the screen and talk about them. So let's get to what we have here. Let's see. Walter says that it's kind of screwed up on Periscope. That any case that is remotely political is going to be lost by conservatives in DC. I agree. I think this is a huge problem, and we need to really consider whether in these high-level political cases against Republicans, that if DC is a fair venue and if a fair trial can be reached here. I'm becoming more and more of the persuasion that it can't be. There's a fundamentally discriminatory attitude that I think most Democrats have towards Republicans. For example, if you read those studies about will a Democrat actually be willing to will a Democrat actually be willing to, have a son or a daughter marry a Republican? And they're just like 60% of them say they would be upset by it. It's remarkable. Eric says, "Oh, we didn't even get to the Afghanistan stuff, right? I just got so dug in. By the way, we're losing Afghanistan. That's something that's happening. This is the stuff I'm seeing here. The speed of the Taliban advance is surprising the Biden administration. We're expected to cut personnel from the Kabul embassy. We're asking the Taliban to spare our embassy in the upcoming fight with Kabul. And there's already opinion about what will happen to women in Afghanistan and other matters. Really quickly on the Afghanistan thing, I just want to, I'll quickly just get through that and then get back to your questions. I don't think any of the blame for the Afghanistan problems that we're seeing should ever fall on the people who said we need to withdraw. The United States has had 20 years to put that country back together, and it's failed. If the government's going to fall in 4 weeks, that's on the people who occupied the country for 20 years and failed to create a robust country. Because otherwise, what you're basically saying is we need to be in Afghanistan endlessly. That argument makes no sense to me. Anyway, back to questions. Quote. Let's see. So yeah, back to this comment. I think we need to start very seriously taking the idea that it's ridiculous that it's impossible to get a fair trial in DC proper. And I think this is also a very good point on YouTube from Uppity G. Quote, yet more proof that access to a fair trial is situational and geographic, especially if you're a conservative, that is a repeat of what drove people to leave Britain to start America. We dropped the ball. It's very similar. It's analogous to the problems facing the January 6th defendants, which is they're also facing the potential of a DC jury. And I think we at Human Events had Shipwreck Crew read an entire article about how fundamentally unfair it was to have DC Democrats ruling on a very profile Trump Republicans' fate, but that's not meaningfully a jury of their peers. So that's something there. Somebody says, Beach Hill says, how did nobody pull Lindell aside and stop this train wreck? I worried immensely about this. And I think I do find it frustrating. Like, maybe they just didn't have good lawyers. Maybe they disregarded the advice of the lawyers, but maybe we all lived in this world where people just thought they could say whatever they wanted to. And so few defamation cases succeeded that people got used to the idea that they really couldn't get nailed on a defamation case. And finally, we had this event where we had people saying things that were so outlandish and also so financially damaging to a big corporation that they suddenly found themselves in the jaws of defamation litigation. Chris Tyler says, this show needs to be more popular. Thank you. I appreciate that feedback very much. If you agree with that, please subscribe, share, do that. The more people share this, the more people watch it, the farther it will go and the more information we'll get. I hope that you guys are enjoying it, getting value out of it. Even if I sometimes am not talking about the things that maybe make conservatives the most happy, I consider myself a really strongly pro-Trump conservative, but I also am a lawyer that wants to do objective analysis. Let's see. As Dave Bears again, it says it's completely corrupt that leftists get to haul people into leftist kangaroo courts where they can't lose. I agree. I think we've been over that. Further. Livestocking says this is actually reason not to even visit DC, New York, or California. And that is, that's one way to try and avoid cases. But I wouldn't plan my affairs around trying to be able to win challenges on personal jurisdiction. It's not smart, just, not just because you're arbitrarily constraining your life, but it's also very difficult to win those challenges. So that's a big problem there. Let's see. Dave Bear says Dominion acted in bad faith the whole time by not challenging any of them publicly or asking for retractions and not suing Dems in 2016-18 over similar allegations. Well, I guess I would make 2 points there. One, they actually have challenged them publicly. They filed public cease and desist letters 6 or 7 months ago. Two, I don't think it's fair to expect people not to make retraction demands and then forego their right to litigation if you said something that's damaged their business. And three, I don't think that, and here's where sometimes life isn't fair. I don't think the Democrat allegations actually really damaged the Dominion's business, right? Nobody was saying we're not going to use you anymore. There wasn't some giant uprising against this particular company from the left. And because that didn't happen, if they tried to go to court on these allegations in 16 and 18 against Democrats, it probably wouldn't work because you have to prove damages to win a case like this. Somebody says, wouldn't Democratic inquiries into ballot machines following 2016 and also concerns from back in 2004 provide a decent defense of reasonableness? I think they would. I think that's a viable argument. And one of the things that's in some of these motions to dismiss or the responses to them from people like Lindell is saying, look, the Democrats said all this stuff too. You can't hold me liable for this. It was perfectly reasonable. It wasn't reckless. I didn't have actual malice. But the problem is now he's going to have to persuade a jury that that's reasonable, and it's going to be a DC jury. I think in front of a Republican jury, that we'd have a lot better shot at winning this. But I think the big problem facing, again, as I said, the Lindell defendants is they've lost their motion to dismiss. They are in front of a judge who thinks they're full of it, and they're going to be in front of a jury who thinks they're full of it too. And so unfriendly judge, unfriendly jury, $600 million on the line. That's a bad combo. So even if in some objective sense, they have the right side of the argument, the best of the argument, all the circumstances surrounding it are so bad that they really do want to settle this. So that's, I think, what's going on. Funny. Somebody says, Shimcast IRL. Yeah. So, that's funny. Or Shamecast IRL. Yeah. We had a fun time last night. If you didn't see it, you should check out the podcast I did with Tim Poole, Seamus Coughlin, who's the guy who does Freedom Tunes, and Ian Crossland, who's Tim's right hand on that podcast. So really, definitely had a good time doing that, and you should check it out. Now, okay, I went all the way back to the very beginning of the show to get comments. Now I'm kind of speeding up and looking at what you guys have said in the last 10 minutes or so. Dave says, on Timcast, I mentioned The Big Short and Pitt's character. He says that in the movie, every 1% unemployment goes up, 40,000 people die, and the left conveniently abandoned that idea last year. They did, but I think we all did. Everybody, I don't know. I'm not a fan of blaming everybody for what they did in the first months of the pandemic, because there was so much unknown. We had no idea exactly how severe, dangerous the virus was. We were guessing. We were all scared. Republicans and Democrats were sort of on the same page, doing the same things. So it's not just the Democrats at that point. I think more now you have to look at, I think in particular, the way that Joe Biden and the Democrats are treating the economy now is disastrous. Things like stopping Keystone and then asking OPEC to release more gas. Things like extended unemployment insurance that is totally unnecessary at this point and is ruining small businesses across this country. It's just, we talked a lot about this on Timcast, but that's something real true. D Field asked a good question. This is good from D Field. Who picks the venue? In a court, the plaintiff has the first chance to pick the venue by filing suit where they want to have the case held. And so, there's some amount of advantage that the plaintiff has where they can just first off pick where the suit's going to be filed. Now, they can't file it anywhere because they still have to meet, there's like a constitutional requirement that there's jurisdiction over the defendant and that venue is proper. But once you the first person to actually pick the venue is actually the plaintiff, who just makes the decision about where to file suit. Livestock says, as far as he's concerned, we are not losing Afghanistan. They're losing their country to extremists. I think that's actually a wise way to think about it. I mean, unless you think of Afghanistan as a colony, that's pretty accurate. Chris Tyler on YouTube says, this is what the Taliban said they would do. Biden pushed the withdrawal back to September when the original date was May. They were not happy about it being pushed back. I can see that. And, it's actually probably a good reason that Biden should have stuck to the original agreement, just because we really were not in a position to effectively stop the Taliban anymore. And so we needed to make sure we were adhering to our agreements to put us in the strongest possible diplomatic position. Echo says, you just came here from Shimcast. Well, I appreciate that. And if you are somebody else who came here, please, if you're new here, hit that subscribe button. We just started with a daily live stream / podcast. So we're trying to, build subscribers, build a viewership, build a following. And I'm hoping that you guys enjoy what you see. Let's see. So Ross says, Cuomo resigning in disgrace, time to distract people by dredging up some Trump bashing. I covered the Cuomo thing 2 days ago. I'm not avoiding news. This is just, I'm doing news that I think is interesting on every particular day. Cuomo resigned 2 days ago. I talked a lot about it that day. I think it's a really good thing. And I don't see this as bashing Trump, right? I'm sad about the outcome here. And I think people, it's not about bashing Trump. I was a Trump guy. It's about reporting on something that's happening to people in our space and understanding that we're in bad shape in this lawsuit. So that's a real thing. Eric asks, how fast could the judge court pull, quote, this evidence isn't valid, end quote, if Powell Lindell somehow present actual incriminating evidence to the court? So there's ways for a court to exclude evidence, right? Especially if it's expert testimony. There's a whole process for evaluating whether someone is in a position to provide expert testimony, evaluating their credentials and their expertise. And that would be before you evaluate that before it even goes to a jury. And so there are ways to exclude evidence, but Generally, judges lean on the side of admitting evidence unless things go very wrong, because that's a very easy way to have a trial get overturned on appeal. If you wrongfully exclude relevant evidence, that's one way. That's a really easy way to lose things. So judges are going to defer to letting things in. I think if they could, and if they actually could present real meaningful evidence that would prove their case, I think the judge would be very reluctant to say no, that you can't do that. Because I mean, it would be relevant if it would go to the heart of the issue, right? If somebody, they could actually demonstrably prove that what they're saying is true, a judge who would exclude that would get reversed on appeal. 100%. Like, I have enough faith in our court system to have faith in that fact, that judges are going to be nothing. There's nothing a district court judge fears more than being reversed, especially on something that's just embarrassing like that. And I think that's what would happen. Is there any remedy for political jury discrimination in jury trials along the lines of the Batson rule? I don't think so. Racial discrimination, sure. Political discrimination, no. The fact that, let's see, who else do we have here? Corporate legacy media routinely says defamatory stuff, even about non-public figures like the Covington kids, and gave it away with it for decades. I mean, part of the problem is that our lawyers have not done a very good job. Like, we don't talk about this, but remember, Lynn Wood is the person that ultimately was in charge of representing Sandman, Nick Sandman. And Lynn Wood turned out to be a complete crazy person. And as a result, everybody talked about, they settled the case and it was, we had sued for $300 million. In reality, I'm almost 100% confident that they didn't disclose the actual settlement amount. They didn't disclose the amount that the Washington Post had to pay Sandman, or the amount that CNN had to pay, or anything like that. And the reason they didn't disclose it is because I'm sure Lynn Wood insisted on that being included in the agreement, so they could parade the fact that they had settled the case without actually mentioning that they had settled it for a trivial amount. That's kind of what I think happened. And I'm not enthusiastic about that. We need better lawyers. And we have some really good ones. Harmeet Dillon is a great lawyer, doing great work. Ron Coleman, others. But we are getting to part of the big problem is that in some of these big cases, we are not getting competent, experienced counsel handling them for clients. And as a result, we are not getting good results. That's part of the problem. And part of the problem is also just, the level of damages. I mean, the big problem here that we essentially the jaws, the sort of terrible, confluence of events is not only were these probably false statements, but they were false statements that damaged $1 billion company for a severe amount of money. And that's never a good spot to be in, because that brings in really good lawyers who see you suddenly as a giant, see your company as a giant pot of gold that they can get access to if they win a case against you. Jeff Johnson says, I think Lindell is causing more damages to the arguments of legit election fraud. The amount of media and social media he has contributed to Democrats is immeasurable. I mean, ultimately, I think that all the Dominion stuff is a giant distraction. I think there are plenty of election shenanigans that happened in 2020. But I think that the argument that there was rigged, basically a completely rigged election at the core is just, I have not seen the basis for that. So I'm very disappointed. The kiosk says, I agree with Tim saying we need transparent election processes. I think that's exactly right as well. And I also don't know that the Lindell situation will help or harm. I think, as I said on Timcast, I think elections need to be they should have the integrity. They should be beyond reproach, right? They should, what was it like? Be beyond suspicion. And it's not the fault of the American people if they don't trust the election process. It's the fault of the process for not being transparently trustworthy. That's all true. And it's something I hope to actually achieve with reform. What else? Let's look at their comments here. There's some troll. Livestock says, you watched me on the Shimcast last night. It was a rocking good time. Highly recommend it. I had a great time. It was a lot of fun. Always like going on Tim's show. Always have. Let's see. Last comment here. Cheryl Nichols, bringing the case forward seems shaky, but the more PR on election manipulation over the last century could be publicized. If postured well, the DNC could suffer as it is now run by ideologues seeking to diminish civil rights. I think if people are there isn't a silver lining. I hate to be harsh. There's not a silver lining here. The only possible silver lining is if there's discovery and you really see something happening for if there's discovery and you actually Lindell happens to be right and is able to uncover some piece of evidence that reveals all, some horrible fraud. I strongly doubt that would occur. Strongly doubt that would occur. And I think you need to do it. Let's see. John says, no questions, but solid show. Keep it up. Thank you again, those of you out there who are new here. I mean, this is show number 4, and it's not like we're doing bad in terms of views, guys. I'm very happy with the response that we've been getting so far. I think on Twitter, at least, we've gotten at least 30,000 views on each of the first 3 shows. I think the second one got like 78,000. So for a brand new podcast, we'll take it. And I'm happy to keep doing this for you guys. And I like, one of the things I love, and I love this about Periscope, and I love doing this on a live stream, is my ability to interact with you. I think the coolest thing about Periscope is the sort of live and your ability to participate in the performance, right? Like that's such a unique thing about live streaming. And it's something I absolutely insist on keeping. And so I like the fact that you can say something in the comments and I will pick it out and respond to it. I think that's very, very fun. And so I want to make sure that, I understand that in terms of making a podcast, it's tricky if the entire podcast is like that, because it's hard to listen to, passively. So I try to make sure the first 30, 40 minutes are podcast-esque, but I always want to make sure that I'm keeping this kind of live stream functionality for what you guys do. So I can take a few more questions here. Dave says, I'm completely black-pilled. The left has gone insane and is weaponizing every institution against us. I'm less black-pilled. I think we still have a way to win power back. And I think ultimately what the left is doing is not that popular. But I think right now, people need to understand that our game needs to be tighter. It just needs to be much tighter, because right now we're getting people's weaknesses are getting exploited. And the Democrats get away with stuff we don't get away with because we don't control the power centers the way they do. In a different world, it would be every major media network who promoted Russiagate facing serious problems on defamation suits from the Trumps. But we don't live in that world yet. We need to work to get to that world. And that's a real thing. Beach Hill says, I really miss these Periscopes. I'm glad that I'm back doing them. I miss doing them. It's one of the things that I enjoy doing most. And I'm actually trying to structure my life and my business affairs to make sure that I can do these things. Part of, I don't have as much day-to-day supervision of the opinion side as I used to at Human Events. And part of the reason for that is so I could focus on doing what I loved, which is streaming with you guys. Paul says, you subscribe because of Tim's show. Thank you. I appreciate that. If anybody else here from Tim's show, if you enjoyed seeing me, if you enjoyed seeing other people, I would strongly encourage you to subscribe. And if you are watching this elsewhere, I probably and if you ever watch on YouTube, go youtube.com/unevents and subscribe. That's the best place to see this particular show at the moment. Somebody says, time to do some Biden bashing. We'll get to that tomorrow, especially if I can find something legal. I always like doing legal analysis. It's the most fun thing to do in these areas. If the audit shows Trump won, will the defamation lawsuits get weaker? Chain Ladder asked this on Twitter. The answer is yes. Right? Truth is a defense to a defamation lawsuit. So if Lindell or Powell or anybody can demonstrate that some of their claims were true, that will help them. But it won't. Weaker does not mean gone, right? Like, even if the audit shows Trump won, that doesn't necessarily mean the audit shows that Lindell and Powell's allegations about Dominion machines were true, or were not reckless, or were not defamatory, right? So the question is going to be, can Dominion demonstrate that Lindell, Powell, Giuliani, Fox, OAN, Newsmax said false things about Dominion machines? And that's a narrower question than the broader question of whether or not the election was won. William Shaw says, recommendations for casual legal education. That's an interesting question. Maybe I'll put together a list of people to follow. I like following people like Ted Frank. But casual legal education is always scary because a little knowledge goes, it can be a dangerous thing, especially in the world of the law. I know that I trip over it sometimes too, just because my practice was not for a really extended period of time. I think maybe, I don't know exactly. I'd have to think about how to recommend what to read to someone who's a layperson and wants to get a better understanding of how the law works. I don't actually have a book off the top of my head that I'd recommend. But there's people on Twitter I respect who I'd recommend you follow. Some of them are not very big fans of Trump. In fact, a lot of lawyers aren't really big fans of Trump, but they're still very good analysts on the law. The kiosk says, I subscribed to this YouTube channel while you were still live on Timcast the previous time you were on before last night. Well, thank you. I appreciate that. I also like Viva Frey. I think he's cool. I like Barnes as well. I think they're all great. All of them really, really great guys. Cheryl Nichols says, just start reading, buy books, and keep reading. Yes, voila. I get so many complaints about my bookshelves, but I love them very much. They're a lot of fun. Okay, well, we're 2:55, which means we're at 50 minutes. That's about as long as I like to go, also because it's as long as my throat lasts when I'm just talking by myself. At some point, I think I'm starting to realize that the reason people always do shows with other people is just to give their voices a break so they don't have to talk nonstop. But I'm kind of like, I feel like Ben Shapiro, I prefer, in some sense, just me, straightforward through it, and to have interaction via the comments so that you get a chance to participate rather than just listening to a conversation. It also forces me to do some work, right? I actually had to like really prepare an analysis of this, and beforehand, I can't just show up and talk, which is sort of what I can do at Timcast, even though I like doing that. Reading is for nerds. But anyway, yeah. So I'll be back tomorrow at 2 p.m. Eastern, like I always am. If you're new here, again, I'm going to keep keeping this promo. Like if you're on Facebook, subscribe and hit the bell for notifications if you're on YouTube, and on Twitter, hit that Twitter live button. And we will be very soon. I promise. We'll be on Apple Podcasts very soon. That's all I got for you right now. Thank you, and I will see you tomorrow.